Thank you. Can I get the next slide, please? Okay, welcome everybody to today's Board of Adjustment study session. Today we have two cases on the agenda for public hearing. And before we get started on discussion of today's cases, we do have two cases that are upcoming for the month of June. For June 25th, we have a property located at 1513 West St. Mary's. That is a tenant space which consists of a laundromat. Currently, they're under 3,000 square feet. They're proposing an addition to that. So that will be exceeding a 3,000 square feet maximum for a laundromat in the zone. So they will be requesting a variance to exceed that. The second property we have is located at 427 North Norton Avenue. This is a residential project. The property owners are doing some renovations to their property. They have an existing guest house that they want to do an addition to. The existing guest house did not have any permits, so they need to bring that into compliance. One of the issues with this guest house is that the guest house sits on the property line. Therefore, they will be requesting a variance to delete the setback. We do have a quorum scheduled for the June 25th hearing, so I'm happy to hear that. So that will be scheduled. And we'll go ahead and get into today's cases discussion. So the first case we have is 2503 Oxford House, Saguaro. This one is Isabel LLC, and it's located at 2601 North Swan Road and zoned R1. Okay, so let me give you a little background on this. So this is an appeal of the zoning administrator's determination that was issued in January of 2025. And it's relating to the restriction on the number of residents that are allowed at the Oxford House. So what is the Oxford House? Just to give you an understanding, it's a facility that provides an opportunity for recovering alcoholics and substance abusers to maintain their sobriety in a supportive living environment that do not require the provision of treatment or counseling services. So this facility does not need to be licensed by the state of Arizona, nor does it require any staff to supervise or maintain the facility. So the residents of the Oxford House, they have access to the entire property. They do not rent by the bedroom. All the household and financial responsibilities are shared among the residents of the facility. So rent and utility bills, they're all paid from a single household checking account. The residents, they share in also the maintenance of the property. So that's kind of a summary of what the arrangements look like at this facility. So how did we get there? So on December of 2023, there was a report of a complaint regarding the property. Code enforcement went out to inspect the property and issued a citation for an unpermitted group dwelling use of the property. This resulted in the applicant, or I should say Oxford House, requesting a zoning administration determination, a formal determination regarding the proposed use. Upon the issuance of the zoning administration determination, the city court closed the code enforcement case, and the zoning administration determination is now subject to the administrative review process. So the Oxford House is similar to other housing arrangements for persons with disabilities, and to allow up to 10 unrelated recovering alcoholics and substance abusers to reside together as family. That's what the zoning determination request was for. They want to make it clear that this is not a group dwelling, and also requesting up to 10 unrelated recovering alcoholics and substance abusers to reside as a family. So in January of 2025, the zoning administrator did find that based on the information provided, the residents of 2601 North Swan Road may be considered a single family. However, the zoning administrator found that how the facility operates is more similar to a group dwelling or physical and behavioral health facility, and therefore place reasonable conditions on the determination. So these conditions are as follows. Total number of residents is limited to 8. Number 2, registration with the city will be required. Number 3, further building permits will not be required, and the assumed existing certificate of occupancy for the single-family home will be considered valid. And number 4, if the use expands beyond 8 residents, the zoning and building regulations will change. Zoning review shall consider the use a group dwelling and will be subject to all zoning standards for the use. Building code review shall consider this a change of use, and applicable commercial building code standards will apply, and a new certificate of occupancy will be required. So the appellant is requesting before the board a modification to the January 27th, 2025 zoning administrator's determination. So specifically, they're asking a revision to condition number 1 to state that the total number of residents is limited to 10, and deleting condition number 4. To date, we have received a total of 1 in support of the appeal and 2 letters that are opposing the appeal. And for the record, the board members have been provided copies of the comments. And I will go ahead and open up discussion at this time.
Mr. Castro, you said that there was a complaint filed about the property that resulted in a code enforcement citation. Was that complaint related to the number of individuals or the use of the property?
Yes, that's correct.
Okay, so it was about the number of occupants that were there.
Yes.
I also have a question. I'm not sure who made the statement, but are recovering addicts and alcoholics considered to be disabled members of the community? And if so, who considers them disabled?
Mr. Chair, members of the board, Ms. Poulos, under the ADA, recovering alcoholics and those recovering from addiction are considered to be covered by the ADA.
Okay, thank you.
Yeah, the question of whether the individual later that presumably relates to designation.
Mr. Chair and members of the board, Mr. Marks, the zoning code actually has a definition for family, and I'm pulling that up right now because it's helpful as we continue the discussion. It's very broad in how you can interpret what constitutes a family. It says any number of individuals customarily living together as a single household and using common cooking facilities. So there's not a requirement for blood relation or anything of that kind to constitute a family. And In contrast, the city's regulations on group dwellings are about renting a bedroom or a specific space that they have sole access to. So the Oxford House is more similar to a family in the determination because they are a group of individuals that live together. They share all the facilities. It's not rented by the bedroom like a group dwelling is. Mm-mm. That's correct.
Single family versus group home destination. How is that critical? Is that necessary for the appellant to compliance with the code?
It is necessary in that the original code enforcement citation was for a group dwelling. And they were cited as such because of what was thought to be how the facility functioned at the time of the code enforcement complaint. After that, they came to the city and said, hey, we actually operate this other way. This is how our facility works. This is how this house works. And so the determination is that they could be considered a family instead of a group dwelling as cited in the original code enforcement case. Does that answer your question?
Right, so there's no dispute whether it's family,
Correct.
whether it's a group home.
It's not, we're not considering it a group home. We're considering it a single family home, but have placed limits on the number of people that can live there.
I'm sorry, Mr. Marks, you're not being recorded. If you can make sure you push in the right button. There you go.
I was not. And hopefully you were able to hear me. You categorize the use as a group home or under a behavioral, I'm not recalling all the terminology, but that category that you labeled it relies on well, first of all, you were trying to find where it fit into the code. And that was the only place you found that this use could fall in the code.
Let me offer a point of clarification. The determination does not state that the Oxford House is a group home or a residential care facility. The determination is that it is a single-family home. That's its use. And we used the other categories of residential care facility and other language in the state statutes to put some limits on the number of residents in this particular circumstance because it does have some functions that are similar to other uses. We are not classifying it as that use, but just putting limits on it based on that available information.
And the number you chose is 8. They want 10.
That's correct.
Where does the 8 come from?
So there's 2 places that were primarily used in the determination to find a reasonable number of residents. So one is in state statutes. There is a limit, not for this type of facility, but similar facilities where it's a home environment, where they allow 6 residents and 2 primary caregivers. I can't remember the exact term in the state statutes, but it's basically up to 8 people in this state statute for a similar type of facility that can live together and they don't trigger additional zoning or building compliance with those codes. So that's one source. And then the second source is in the UDC and our zoning code, we have a category for residential care facilities. And in most residential zones, those are limited to 10 residents based on the character of maintaining the character of a neighborhood and keeping it still in fitting with that. And then the last thing that I'll mention that I think was mentioned in the determination is this home is a little bit, excuse me, unique in that it has a long permit history, and it was, from what I understand, used for a religious order at some point in time. And so there are quite a few bedrooms in the home. Prior permits for the facility do show that at the time that it was reviewed by Planning and Development Services many years ago, there was a limit of 8 that was placed on the facility of unrelated individuals living together.
Mhm. Okay, so that explains the 8 versus the 10. That is one of 2 items that the appellants are appealing. The other is number 4, and number 4 is dependent upon number 1. They're related. So if hypothetically we were to uphold number 1 as you've written it, condition number 1, then number 4 is essentially moot.
Yes, that would be correct. If you uphold condition 1, then condition 4 would remain as is because condition 4 is related to the number of residents. If
So if
you,
we were to uphold number 1, we would automatically be upholding number 4.
that is correct.
Okay. Okay, I think that is all that I have.
I had one more question. In your staff report under issue 2, you talk about the historical permit records from 1991 indicating the 12 bedrooms. Thank you for the clarification about why somebody would build a house with 12 bedrooms. But you also state that the occupancy was considered R3, but isn't the property zoned R1?
R3 is the building code classification.
Right.
It's not a zoning code, so those are different categories.
Okay, so it's a building code classification.
Yeah.
And those historical permit records, were those permits ever rescinded or modified that you could find?
Not to my knowledge, no.
And do you know, when you say that the building must house less than 8 persons not related by blood, do you know what that permit was requesting when that statement was made?
I don't recollect off the top of my head all the details of that permit, as it's been a little while since I looked at it. But I seem to recollect that it had to do with some modifications that they were making to the interior of the building in order to make it function for the religious order that was going to be there. But I don't remember much more than that.
Okay, thank you.
Yeah, I have one question. Having dealt with a number of facilities, similar nature, I'm wondering why this isn't being considered as a.
Mr. Chair, can you
What?
turn your mic on? Is your mic on?
It is on.
There,
yeah.
okay.
Okay, you hear me now? Okay, I'm curious to know why this isn't being considered as a behavioral health facility. Because it fits that category almost to a T. And I've dealt with a number of others that were very similar in nature and were considered as a behavioral health facility.
Mr. Chair, the distinction here is that for residential care facilities in the zoning code, they are intended for individuals that cannot live independently and they need some level of care from a caregiver in the facility. In this case, there is no caregiver. They do not require oversight of meals or any of their daily functions. They live independently, just in a group setting.
Thank you.
You have one more question, and that is of staff. Yep, I guess I'm on mic now. And that is there another example that you've dealt with in the city that falls into the same category?
Mr. Chair and Member Marks, are you asking if there's another facility that we've classed the same way as this facility in this determination?
Yes.
Not that I'm aware of, no.
Okay.
Are there any additional questions regarding this case?
Yeah, I have a couple. I'm wondering, so we've talked about the family definition, and that the residents of this home, since they're living independently and not receiving services, that they fit that definition. However, there are still reasonable limits being placed upon them. So I guess I just wanted to clarify, if this were just a normal family and it wasn't Oxford House, would the city have any grounds to enforce a limitation on the number of residents?
Mr. Chair and Member Schubert, I think your question is essentially if we can limit the number of family members that live together in a potentially a more traditional situation than the
Yeah.
Oxford House.
Exactly.
I would say no. The distinction being, I think, for me in the Oxford House case is what the intensity of the intensity of the residents and their use of the facility as compared to maybe a more traditional or typical family setting, being that it's 8 adults that are living together versus maybe a different dynamic of a family. So that would be some of the rationale for why there's a limit compared to what the city could do in a different circumstance.
Thank you. And then my other question had to do with the fair housing protections on discrimination against certain classes like ADA. And if there are more details that can be provided about that. I understand that the residents in recovery fit the definition of ADA.
Mr. Chair, board members, that's correct.
So I guess I just want to check my understanding because I feel like part of this appeal has to do with alleging that there may be fair housing discrimination in this case, since the only distinction between this living situation and traditional family situation, I would allege that there's no traditional family, but that the only difference between these two settings would be that the residents are recovering alcoholics and substance use addicts.
If I understand the question correct, that is correct, that's the allegation of the appeal, and that having a distinction like that does violate the ADA. I think there's some discussion about that within the staff report as well.
Thanks, that's all I have.
I'd like to add one item to that. In my understanding of fair housing and ADA, and this case in particular, the city has to be able to say that our zoning provides access to all of those groups in all parts of the city. It doesn't say that we can't limit it or put reasonable boundaries on that, as long as the access to the housing still exists.
Thank you. I understand.
I have a point of clarification, Ms. Hamblin, based on the questions that you just received. If there is a permit from 1991 and there's a condition that the building must house less than 8 persons not related by blood, isn't that another justification for the limit that you imposed on this facility or not?
It is a justification, I believe. It was cited in the determination as a factor as well.
So if for some reason we decided to increase that to 10 people, do we also have to go back and revise that condition from that permit?
That's a good question. I think there was a motion template that was provided to the board, giving some options on how you might want to look at this case. And based on recommendations from the city attorneys, if we do modify that condition regarding the building standards, that, which is condition number 4 in the original determination, that we would recommend that it's phrased that the use will be subject to all applicable building codes. So, because that's kind of outside of the purview of zoning to say exactly what building codes and permits and all things would be required. So if there was, a desire to modify those conditions, we need to make it clear that building codes still apply, and that's not within our purview to modify those with this request.
And just to clarify that a little bit, the scope of this review is to determine whether there was an error in the zoning administrator's determination interpreting the UDC. So it's a narrow scope that's limited to the interpretation of the UDC. So not only will the building code be addressed separately, depending on what this commissioners decide, but also a reasonable accommodation request, if necessary, will be addressed separately by the city. That's not within the scope of what we're determining here today.
And I'd just like to clarify, the speaker that just spoke to us was Shelley from the city attorney's office.
Do we have any additional questions regarding this case from the board members?
No, I think we're done.
Okay. Let's go ahead and move to the next slide, please. So the next case we have on today's agenda is C-10-2504, Fresina Residence New Carport, Joseph Fresina, 7043 East Hain Place. So this is a request by the property owner to construct a new carport located at the southwest corner of the property. The applicant is before the board requesting 2 variances. One variance is to reduce the front street setback from 30 feet to 10 feet. And the second variance request is to reduce the side perimeter yard setback from 10 feet to 6 feet. We have received 3 written approvals regarding this project and 0 protests. And I'll go ahead and open it up to discussion at this time or questions.
I do have a question or two. The property in question, was it in the county at the time it was platted? I think I read some reference to that.
I believe it was. I can pull it up here in the staff report.
So the required setback, is that a current city requirement, or was that one? Because the reference as shown on the plat,
Correct.
what does that mean? That plat was reflecting the then county setback.
So traditionally, we usually have a 20-foot front street setback in the UDC. What's unique about this is that this property is located in a subdivision that was platted with a specific front street setback requirement, and that was 30 feet. So that's why the applicant is here before the board requesting a variance to reduce that setback. Otherwise, they could go through an administrative process for using a design development option.
So the 30 is as shown on the plat. What is the current or the existing city setback?
Currently, it's 20. We
It's
require.
20, yeah, you probably just said that. Okay, so it's actually within the city definitions, a reduction of 20 to 10. Okay,
Correct.
gotcha. Thank you.
And Mr. Chair, members of the board, just to clarify, when this plat was approved, it was in the city of Tucson, not Pima County.
I didn't hear that.
The plat was approved originally in the city of Tucson.
Oh, it was,
It was.
but that reflects a county setback?
I'm not sure where the setback came from, but it was recorded on the plat in 1957 within the city of Tucson.
Mm-hmm, okay.
So is it a recorded plat, a development? In other words, a lot of developments have been built around here to really set up their own setbacks and their own things that are not necessarily in compliance with the city of Tucson's codes until, of course, somebody applies for a permit. And I know for a fact that the city is not interested in upholding or adhering to a code or setback requirements in any particular development area.
Mr. Chair, could you repeat the question? I'm sorry, it was.
Oh. Yeah, I'm sorry. I think I was referring to a lot of developments are developed and they establish their own setbacks, right? You know, they build multiple houses in multiple areas and put in the streets and the utilities and the lay out the property lines, and they will have their own set of covenants and restrictions for that particular development. And it, as far as we know, this may be in compliance with that particular covenant and say, but as I think I'm aware that the city is really not in any position to uphold those covenants and restrictions, and that really it's the city code that applies to any modification to the building. Isn't that right?
Mr. Chair, I think the question you're asking is basically regarding what private agreements might be made in a particular area or a plat or a subdivision. So you are correct that there's covenants and restrictions that get recorded with a subdivision typically. Those are privately enforceable. They're basically a contract between the property owners within that subdivision. By contrast, a plat is a recorded document with the city, which essentially can set certain limits. It's very common, for example, in hillside areas where there will be larger setbacks or certain areas where there's environmental resource zones you can't encroach into, things like that, where the plat identifies kind of those specific areas because it's particular to that location. I don't know the rationale behind this particular plat and why they made that requirement slightly larger, but that is a recorded document with the city by contrast to a CC&R, which is between the private property owners and how they govern themselves.
Okay, thank you.
Hypothetically, we could approve that reduction. But given that this setback, I infer by the language in your staff report, is depicted on the subdivision plat, either by a line on the map or as a note in the note section on the plat, would they also need to get what is referred to as a plat note waiver?
Not that we're aware of. We think a variance is sufficient for the request for them today.
Okay.
Do Do we have any additional questions from the board?
I think that's it.
Okay, we'll go ahead and close study session now and go into start the public hearing if the chair desires.
Okay, let's open it up. Mrs. Hamlin, roll call, please.
Bruce Dawson,
Here.
Miranda Schubert,
Here.
Irma Duran,
Here.
Bonnie Paulus,
Present?
Michael Marks.
Here.
Mr. Chair, we have a quorum.
Thank you. Ladies and gentlemen, welcome to the regular meeting of the, excuse me, City of Tucson's Board of Adjustments. This meeting is being recorded, and by joining, you are giving consent for this meeting to be recorded. An introduction of each case will be made by staff. At the conclusion of staff's presentation, the applicant or the applicant's representative will have an opportunity to speak. For the record, please tell the board your name and address and state your request. At the conclusion of the applicant's presentation, other persons wishing to speak in favor of the request may come forward and state their support. When called by the chair of the board, those wishing to speak in opposition to the applicant's request may come forward and state their protest. The chair may allow applicants the opportunity for a brief rebuttal. The chair will then close the public hearing and open up a discussion by the board members. At the conclusion of the board's discussion, a motion will be made and if seconded, will be voted upon. All presentations today must be directed solely to the board and not to staff or members of the audience. All presentations to the board must also be only on the items brought before the board. Presentation on matters unrelated to the request will not be heard. A discussion of the Board of Adjustments may be appealed to the Superior Court of Pima County by filing a complaint for the special action with the Pima County Superior Clerk's Office within 30 days of the board's decision. For additional information on this filing process, please contact Superior Court Clerk's Office or an attorney after today's public hearing. If you are going to give testimony today, please be brief and to the point. Repetition of testimony already given by other witnesses is not necessary. The chair may invoke a time limit if deemed necessary. Before you testify, please remember to sign in on the roster sheet on the clipboard of the podium. If you are joining us remotely, please state your name and address for the record. All testimony to the board must be given under oath. If you're going to speak or think you may speak today, please stand and raise your right hand at this time. You swear to tell the truth and nothing but the truth, so help you?
I do.
Thank you. Please turn off all cell phones. Please turn your cell phones off in silent mode. And if you are joining us remotely, please be sure to mute yourself and turn your camera off unless you are addressing the board. Mr. Castro, please call our first case.
Mr. Chair,
Yes.
I'd like to be heard. Given that case C-10-2503, the Oxford House issue, is rather complex and has generated a lot of questions, I would like to make a motion to rearrange the order of our cases today such that C-10-2504, the Frisno residents' new carport, would be heard prior to the Oxford House.
Can I have a second to that motion, please? Okay, good. All those in favor say aye. Aye.
Aye.
Aye.
Motion carries. So, Mr. Himmel, we'll start with the Fresina residence, new carport, please.
Thank you, Mr. Chair and members of the board. Our first case is C10-25-04, Fresina Residence New Carport, Joseph Fresina, 7043 East Hain Place, R1 zoning. The applicant's property is an approximately 8,150 square foot lot zoned R1 residential and is developed with a single-family residence. The applicant is proposing to construct a new carport attached to the southwest portion of the residence. The applicant is requesting the following variances. 1, allow the construction of an attached carport with a reduced front street perimeter yard setback from 30 feet to 10 feet as measured from the south lot line. And 2, allow the construction of an attached carport with a reduced side street perimeter yard setback from 10 feet to 6 feet as measured from the west lot line, all as shown on the submitted plans. Planning and Development Services staff has no objections to the applicant's requested variances. Should the board grant the requested variances, staff recommends the following condition. A, no parking in the area between the carport and street. It is the opinion of staff that there are special circumstances applicable to the property that granting of the variances would not be detrimental to the public welfare or injurious to other property or improvements in the neighborhood in which the property is located, and that the variances requested are the minimum needed to afford relief and the least modification possible of those UDC provisions which are in question. To date, we have received a total of 3 written approvals and 0 written protests. For the record, board members have been provided a copy of their approvals. Mr. Chair and members of the board, this concludes staff's presentation. I would be happy to answer any questions.
Are there any questions for staff? Turn on your microphone.
There we go, there we go. And it has to do with the 6-foot dimension at the rear of this, on the street side. First, clarify the front versus the side. The front is along Hain, is that correct?
That is correct.
And so the side is Burge.
That is correct.
And so there's a 6-foot dimension at the closest point between the proposed carport and, well, the spandrel between those 2 street intersections. Did the Transportation Department review that and find that it really or results in a sufficient site visibility around that corner?
No, it did not. It was not part of the review. This review included site zoning, residential, and engineering. But engineering typically reviews for floodplain.
Okay, so nobody's looked at it from that standpoint.
Correct.
Okay, thank you.
Any further questions for staff on that?
No.
Okay. I'll close that portion and open the floor to the applicant. If you may make your presentation now.
Hi, members of the board. Thank you for hearing me. My name is Joe Fresina, 7043 East Hain Place. This is in regard to the variance for the carport. At first, I think I'd like to address the board member that was just speaking about the traffic, for the visibility around the corner. This is a cul-de-sac. I'm on the corner of a cul-de-sac with only 4 houses on the cul-de-sac. There's not much traffic going in or out either way. The entire neighborhood is cul-de-sac, but I'm on the corner of of the end of one, and so it's set back far enough that I don't think it'll have any visibility or issues with that. We wanted to do it on this corner of the house because the east corner of the house side of the property, we're next to a vacation rental, and we've had problems with them throwing trash, throwing bottles, stuff in our yard. We'd hate to have our cars over there right next to that, so that's why we want it on the other side of the property. the slope on the east side of the property, of the street, the sidewalk is higher than the foundation of the home. So it slopes, it's a negative slope sloping towards the home. And on the west side of the property, it's more of a level, it's more level. So that's also more conducive to having the carport on that side. There were windows on the east side of the property, the bedroom windows. We didn't want to cover up all the bedroom windows with a big carport. So also more conducive to the other side of the property. I have a few pictures of it if anyone would like to have some renderings that we made, just showing that it's going to go with the original construction. It's going to really look like it was built in. All of my neighbors have been happy about it and excited about property values going up. And I think that's about all I have.
Do we have any questions for Mr. Frazina?
I have a question of the applicant. In my reading for this case, there seemed to be an indication that this house once had a carport that had been enclosed and used as a living space. Is that on the west side of the house? And
That
is
is. That's
that
gonna
an
go-
accurate understanding?
Correct. It's going right in front of that closed-in carport, and that's what we would have used as a carport. But with that being enclosed, we really didn't have much choice as to somewhere else to throw it in the front yard.
And also, staff has recommended a condition be placed on this variance about no parking in the area between the carport and the street. Does that pose any problems to you with the number of vehicles that you anticipate?
None whatsoever.
Those are all my questions.
Any other questions? Okay, hearing no other questions, thank you very much. I'd like to ask if there's anyone else that wishes to speak in favor of this. Hearing none. About to get to that part. Thank you. Now, is there anyone opposed to this application? Hearing none, I will now close the public hearing to this case. And I will open it to discussion of the board.
I see no problem with this request. I think staff has made a reasonable determination. If there are no other comments, I can make a motion.
Please
But
do. Yeah.
Okay. I move that C-10-2504, Frazina Residence, New Carport, 7043 East Hain Place, that we agree to allow the construction of the attached carport with a street perimeter yard setback from 30 feet to 10 feet as measured from the south property line, and to also allow the construction of that carport with a reduced side perimeter yard setback from 10 feet to 6 feet as measured from the west property line as shown on the submitted plans. In addition, there is a condition that we will place on this variance that there be no parking in the area between the carport and the street. Let's see, I think if I make that motion, hold on, there's some other verbiage I need here. The evidence presented to the board shows that there are special circumstances which were not self-imposed, which are applicable to the property and support the requested granting of the requested variance. Specifically, this will not do any harm to other properties within the area. It will not impair any light or air issues or diminish the property values within the neighborhood, and that the variance, if granted, is the minimum variance that will afford release and is the least modification possible under the UDC provisions that are under consideration.
I will need that motion to be seconded.
I'll second.
It has been moved and seconded. Any further discussion? Hearing none. All those in favor of the motion say aye.
Aye.
Aye. Motion carries. Thank you very much. Good luck with your project. And thank you.
Thank you all very much.
Okay. Let's open up the next case, please.
Thank you, Mr. Chair and members of the board. Our next case is C10-25-03, Oxford House, Saguaro, Swan Isabel LLC, 2601 North Swan Road, R1. The appellant, Heather Dukes, on behalf of Swan Isabel LLC and Oxford House, Saguaro, is appealing the zoning administrator's determination TZ-CMP-0724-00095, issued January 27th, 2025, relating to the restriction on the number of residents allowed at the Oxford House. A zoning administrator's determination is a request for clarification or determination in connection with a pending application or request for approval and the identity of the proposed project or development. Pursuant to Unified Development Code Section 1.5.1.e, a party of record can appeal the zoning determination. The appellant contends that portions of the determination which limit the number of residents and impose group dwelling zoning and commercial building code standards to properties with more than 8 residents are arbitrary, capricious, and an abuse of discretion and violate the Fair Housing Act. The appellant is requesting, excuse me, a modification to the January 27, 2025 determination. Specifically, the appellant requests a revision to condition number 1 to state total number of residents is limited to 10 and deleting condition number 4. The appellant raises 4 issues. 1, the determination violates the Fair Housing Act by limiting all Oxford houses to 8 residents when the UDC, 1, does not provide a resident restriction on family uses, and 2, allows up to 10 residents and other group residences for persons with disabilities. Issue 2, the determination is inconsistent with the city's building and fire code provisions, which allow 10 residents to reside in a dwelling with a residential R3 occupancy classification. Issue number 3, the determination erroneously applies an inapplicable statute for persons with developmental disabilities as a basis for limiting Oxford houses to 8 residents. And issue number 4, historical permit records for 2601 North Swan Road should not be used as a basis for limiting all Oxford houses to 8 residents. Planning and Development Services recommendation. Given that the UDC does not provide a land use classification for the Oxford House to fall under, and that the zoning administrator in her authority under the Unified Development Code referenced the UDC and the Arizona Revised Statutes, which is analogous to how it operates and provides a reasonable basis for the decision, and that the determination does not set precedents for future Oxford House facilities, and therefore the decision only applies to 2601 North Swan Road, staff recommends upholding the zoning administrator's determination. To date, we have received a total of 1 letter supporting the appeal and 2 letters opposing the appeal. For the record, board members have been provided a copy of the letters. And Mr. Chair, members of the board, this concludes staff's presentation. I'd be happy to answer any questions.
Are there any questions for staff?
Yeah, I do have one, and we might have touched on this in the study session, but let me ask this anyway, and if it's repetitive, I apologize, but it appears to me as though the parties really are not in disagreement over anything other than the number of units that has been placed as a limit on the use. The zoning administrator has placed the number of 8, and the appellant, or the appellant has argued in favor of 10. I'd like to ask staff again, if that was what I asked before, what is the basis of that number? And what is the context of that, of any such restriction? And I believe I've read the context, but I'd like you to clarify that, and that is that you believe that it's one of a number of reasonable conditions that can be placed on the property, on the use, given its similarity with other uses in the zoning code, given the fact that it, in your opinion, does not exactly match a use explicitly described in the code. Is that fair to say? If all that's fair to say, and we will get to the appellant after, but starting with the zoning administrator, is that a fair context? And if it is, what is the basis of the 8?
Mr. Chair and Member Marks, so to summarize a couple points that you brought up in your questions, as a reminder, a zoning administrator determination is allowed per the UDC. It's generally when a use or an interpretation of standards is applied in a way in which the applicant does not agree, or they want some further clarification on how it might apply in a particular circumstance. In the case of this determination, we do not have a defined use in the UDC that seamlessly matches this facility. So in practice, the determination is used in a situation like this to say it is closest to this use, and there can be some conditions or limits placed upon that because it doesn't exactly fit into that use. So to answer your question as to why 8 was determined, in this case, we first answer the question of what is the use? It's closest probably to a family use, doesn't exactly fit the way that we might typically see a single family home operating. So there are some similarities in some of the other uses in the UDC and in state statutes that were referenced in the determination to justify why a limit of 8 would be appropriate.
Can you specify what that is? It's in the staff report. Could you just state the critical item that you used?
Mr. Marks, there are a few different items in the actual determination itself that are referenced. The first being a group dwelling, which again, we are not saying this is a group dwelling, but a group dwelling does limit to 5. Additionally, residential care facilities are limited to 10. Those are both per the UDC. Per ARS or state statutes, there's similar type facilities which are for people with developmental disabilities. Those are limited to 8. And lastly, the reference to the historical permit records that referenced 8 as well.
Okay. Thank you.
Any other questions for staff? Hearing none, I will now open the case to anyone wishing to present in favor of this, the applicant, the appellant, pardon me, thank you. Yeah, we do need to hear from the appellant.
Good afternoon, Chairman Dawson, members of the board. My name is Heather Dukes. I'm an attorney with an address of 5527 North 25th Street in Phoenix, Arizona. I'm here today on behalf of Oxford House. I'm also representing the property owner in this matter. And I have some slides that I've prepared for the board, if they can bring those up. So this is on this first slide, this is a depiction of the home from Swan looking west. And as you can tell, this home is very much like any other residence in the neighborhood. It is a single family residence that's being used as a home by 4 individuals at this time. And we are asking for the home to be used by 10 individuals who are disabled. If you can go to the next slide, please. I want to give you a little context of the vicinity of the area. So the home is where that yellow star is. It's along Swan Road on the west side, just north of Grant Road. What's really important about this area is that sometimes when residents come to an Oxford House, they may not have a vehicle right away. They are required to have a job or to provide so many hours of community service. And so it's really beneficial to have a nice home in a nice area that has a lot of access to commercial retail and office uses. And so at this corner, you have a Fry's, you have a movie theater, you have several places to eat, to get coffee. Further to the east, you have medical facilities, doctor's offices, the Children's Hospital is farther east. And so this is a very ideal location for a home in Oxford House. And you can go to the next slide, please. This is a aerial photograph taken from 2024 Google Earth. The property is quite large. It's part of the San Carlos Neighborhood Association. It's a 1-acre site. The house is about 5,400 square feet. It does have 12 bedrooms. And so there's a lot of parking available in the rear yard. So if residents do have vehicles, they're out of sight, out of mind, they're in the rear of the house so that you don't have a bunch of cars parked out front. While I'm on this slide, I do want to reiterate the zoning district is R1. That's a single family zoning residential district. The occupancy classification under the building code is R3, and that's usually for families as well, with a limit of 16 people in the building code that are non-transient, meaning that they live here. They're not part of like a hotel or a motel, they live here. So in the building code, you can have up to 16 people. The fire code, on the other hand, Tucson allows up to 10 people in the R3 classification. So that's what we're asking for. We're asking for 10 people under the zoning, 10 under the building code, and there's 12 bedrooms again. So we think that this is very reasonable to request. One of the things that I wanted to touch base on was how this came before you. There was a code enforcement complaint back, I think in 2023, and I have Peter Williams here, who is the president of, or the chairman of the San Carlos Neighborhood Association, who'd also like to address you. The neighborhood initiated the complaint based on the use. It wasn't the number of residents, because the complaint was actually filed before we even signed a lease. So they noticed some activity. There had been some history of this property used for, again, religious organizations by the old Pueblo Community Association, which is another nonprofit group that provides housing. And so the neighborhood was concerned because they wanted to make sure this is being used properly. So we went to a code enforcement hearing before the Superior Court judge. We had, I think, 3 or 4 hearings. And what we came to is this ZA determination. The judge accepted it, finding that we are a family use. And we put on the record that we were going to dispute the number of residents because, and I'll get into that for a minute, but the judge accepted the ZA determination that this is a family use. He dismissed the case. The neighbors were present at the hearing. And so that's what we've done. Now we've come to the city to determine the number of people based on this family use. And since the court hearings, we've met with the neighbors, the San Carlos president, the adjoining neighbors all around our home, and they are in support of the 10 residents. And Peter Williams can attest to that on the record here today. We have gone out of our way to describe the use to make sure the neighbors understand that we want to be part of this neighborhood as a family use. We want to join the potlucks. We want to be part of the neighborhood cleanup. And I think that they feel comfortable at this point. We've done a lot of community work since those initial complaints were filed, and then to today's hearing. You can go to the next slide. So this is a floor plan of the residence, and the area that's delineated in blue are the 2 kitchens. And the rest, you can see the bedrooms along, the the east part of the house and the west part of the house. And so one of the things that's come up is the permit records for this home. So in the ZA determination and in your staff report, staff makes note that there was history, and I'm just going to read this into the record. The historical permit records from 1991 indicate there were approximately 12 bedrooms in the home at that time, so 1991, and that's the same as it is today, 12 bedrooms. That the occupancy was considered R3. So again, that's the building code occupancy for a single family home. There is also a condition that states building must house less than 8 persons not related by blood. The floor plan indicates 2 kitchens, which may illustrate a caretaker's family living quarters, which are separate from the other bedrooms. Without complete permit records, it is unclear the circumstances for this plan. So the staff is admitting that there's this condition in the record, but they don't really understand how it came to be. And what's important is you see to the right of this floor plan where the smaller kitchen is, it looks like it would be caretaker's quarters. So what you could have here is a family, let's say a mom and a dad, 6 kids, but then you have caretakers, and that's limited to 8 unrelated individuals in the caretaker's quarters. We don't really know why that permit was stipulated that way. We do know that in the history of this house, we've had some religious uses. Nuns lived here. And then Exhibit 6 to my appeal, there's email correspondence with a former city planner where we talk about how we're going to offer transitional living for 28 male participants as part of the Old Pueblo Community Foundation. So there's been up to 28 people living in this home that the city knew about since 1991, because that email correspondence occurred in 2004. What's important is that the use we're coming to you today is Oxford House. This house has never been used as an Oxford House. And so when we ask for the permission of this use and what the ZA determination, which use applies, that's under today's current standards and current zoning ordinance. It doesn't matter why the house was stipulated to 8 back in the day. What matters is that we're looking at the zoning ordinance today and the limitations that are in the definitions in the zoning ordinance today. You can go to the next slide. So again, we're not appealing the determination that this is a family, and that's what's highlighted in yellow. On page 4 of the ZA determination, it says, my determination that the inhabitants of the property at 2601 North Swan Road may be considered a family per the UDC. Furthermore, the use shall be considered a single-family detached use. So once the zoning administrator makes that determination, so the ZA has the authority to interpret and enforce the zoning ordinance. When we come to her and say, this is our Oxford House, this is what our use is, and she makes the determination that it's a family use, she can't change the definition of family. She can't arbitrarily pick 8 people and apply that to us because she can't change the zoning ordinance. Only the city council can do that. So that is an ultra virus decision to say we're only limited to 8 when there is no provision in the UDC that limits a family use to 8 people. So that is what's key here. So if you go to the next slide, what we are in fact appealing is condition number 1 and 4. And during the study session, it was brought up that if number 1 is upheld, then number 4 should be upheld. I would also propose that if number 1 is changed, the total number of residents is limited to 10, we would agree to number 4 saying that we must comply with current building codes and fire codes, period. We would agree to that. Because again, we're establishing a new use at this property. And so we would comply with current building and fire codes. We'd be willing to do that. And I agree with the city attorney's office that you're not here today to decide the building code issues. You're only here to decide the uniform development code issue, which is number 1 today. So we can go forward with the next slide. So I want to go through the definitions briefly that the zoning administrator has at her disposal. This is the definition of family that she's placed on page 2 of her ZA determination. It says, per the UDC section 11.4.7.f, a family is considered any number of individuals customarily living together as a single household and using common cooking facilities. Now, there's been some discussion that we don't meet that definition, that traditional family definition. We are any number of individuals. We want to have 10. We are customarily living together as a single household. Single households are defined in the zoning ordinance as oh, that's not defined, I'm sorry. So in a single household, this usually means under fair housing, it's doing chores together, it's cooking meals together, it's doing property maintenance together. We're doing all of those things together, our residents are. And we're also using common cooking facilities. Those are the kitchens. So all the residents use the kitchen facilities to store and make their food every day. So I would argue that when she made the determination that we are a family, we are truly a family. We don't meet the traditional sense of family. We actually do meet the definition of family under the zoning ordinance. And so the key fact here in that definition, there's no limitation on the number of individuals. That's what I really want to hone in on. And you can go to the next slide. The next definition she addresses in the zoning administrator's determination on page 2 is a group dwelling. And I think there is a statement on the record here today that group dwellings are limited to 5. They actually are not limited to 5. The definition says 5 or more unrelated persons. So what's key here is, again, even group homes, which are normally inhabited by people without disabilities. People that are in sororities, convents, dormitories, they're renting out that individual bedroom. There's no limitation on the number of people you could have in those. And so again, no limitation is the key factor. We are not this use, again, because we're not leasing individual bedrooms. And also group homes are not allowed in the R1 zoning district, so we couldn't be considered that use. So we can go to the next slide. And this is a copy I submitted into the record as Exhibit 7 of our lease. And you can see that the use of the premises will be a single-family residence, a private single-family residence in accordance with the concept and system of operations of an Oxford House. The entity that's leasing from the owner is Oxford House Saguaro. It's not being leased by individuals. There's a subletting provision in the lease that they're not allowed to sublet the premises unless the landlord allows it. And there's nothing in there about leasing separate bedrooms. So we are meeting the definition of family in that regard and not group home. You can go to the next slide. The last definition in the zoning ordinance that it's addressed is residential care services. And there's a question about why we wouldn't be considered residential care services rather than a family. And it's because typically residential care services are the residences that are licensed by the state. They're your behavioral health residential facilities, your sober living homes, all those are licensed by the state. There's usually some type of supervision. There's some type of care being administered. In this is purely residential. These individuals are not receiving any counseling services on site. There is no supervision. They are peer-led, meaning they make decisions together. They vote on things together. There is purely no care or supervision taking place in the home. And so what I'm going to show you is that in the zoning administrator's decision, she talks about that these residential care service uses are generally limited to 10 residents. And if you go to the next slide, there's a table in the zoning ordinance and the light is shining. So I think it's UDC section 4.7.8. It shows that the residential, the R1 zoning district, that residential care services, including the physical and behavioral health subcategory, is permitted in the R1 district with a maximum of 10 residents. There's no use permit required. There's no other zoning ordinance requirement. It's up to 10 people, even in those residential care services. So just as a recap, if you're a residence or a family, you are permitted in the R1 district with no max. If you're a group dwelling, there's no max on that, but you're not permitted in the R1. And then residential care services, there's a limitation of 10, but you are allowed in the R1. You can go to the next slide. Next slide. So our argument here today is that just based on the zoning ordinance, if we are a family, There's no limitation on the number of residents. You can't distinguish between a family of a mom, dad, and 4 kids and a family of 10 individuals who have a disability, because the only difference between those 2 homes is the disability. It's only the disability. So that's where the Fair Housing Act comes into play, so that if we are a family, there cannot be a limitation. We are trying to be reasonable in putting a limitation on ourselves. We have met with the neighborhood. Initially, we asked for 14. Throughout the court hearing, we brought that down to 10 because we looked at the zoning ordinance and we saw that other group home, like residential care type uses, had a limitation of 10. So we said, okay, we will limit ourselves to 10 also. And so that's what we're asking for, is just for the zoning ordinance to be applied consistently to us and for us to be limited to 10. Briefly, I want to address the state statute argument. The zoning administrator's determination said that although the Oxford House homes are not regulated by the state statute she's about to cite to, that per ARS 36-582, there are limitations on the number of persons with developmental disabilities that can reside in a home. If you have 6 developmentally disabled people in a home and you have 2 caregivers, they have to be treated as a family. If you have more than 7, then the city can come and say you need to get a use permit or a conditional use permit. You can have some type of special zoning approval if you have more than 7. And the reason for that, you can go to the next slide. This statute, this 36-582, if you look at the definitions, developmental disability means autism, cerebral palsy, epilepsy, or cognitive disability. Those are very intensive disabilities that in the event of a fire, they need help usually getting out of a home. You have to limit the number of residents under the building code or under the zoning ordinance sometimes so that there's enough staff present to help those people out in the event of a fire. We are 100% ambulatory. Our guys do not need help getting out of the house. And so this is a very different statute we're talking about here. It also doesn't apply in Tucson, and I'll tell you why. If you go to the next slide, there is a subsection L to this statute, and it says, this article shall apply only to those governmental units which have adopted zoning ordinances which place more restrictions on this type of use. And so if you go to the next slide, if you look at the zoning ordinance for Tucson, they consider that physical and behavioral health service use. So the physical and behavioral health service use is defined. It says typical uses include group homes for the developmentally disabled. So if you go to the next slide, they limit those to 10. Remember the maximum of 10 residents? So Tucson does not require a conditional use permit for 7 or more in the developmentally disabled category. They allow 10 as of right. You don't need any other further zoning approval. So the subsection L of that statute says that statute doesn't even apply to Tucson because they're not more restrictive. They're less restrictive than the state statute. So they cannot use that statute as a basis to now restrict our disability to less than 10. Based on the statute itself, the language of the statute. You can go to the next section. I want to briefly touch on the Fair Housing Act because a key part of the Fair Housing Act is that zoning ordinances have the right to regulate uses. They have that right. But what you can't use is the zoning ordinance to discriminate against persons with disabilities. And so if you allow families to live in houses, you have to allow families with disabilities to live in the same type of houses in communities of their choice, and you can't place special restrictions on them based on the disability. In this joint report, this was issued by HUD and the DOJ, and it's attached as Exhibit 5 to our appeal. If you go to page 3, it says examples of state and local land use and zoning laws or practices that may violate the Fair Housing Act. And the first one, it says imposing restrictions or additional conditions on group housing for persons with disabilities that are not imposed on families. So in this case, there's no limitation on the number of residents that are a family. There's no limitation at all on the number. In this case, Tucson is imposing an 8-person limitation just because they're disabled. And then the next highlighted bullet point says, it could be discrimination of the Fair Housing Act if you refuse to provide a reasonable accommodation to a land use or zoning policy, when such accommodation may be necessary to allow persons with disabilities to have an equal opportunity to use and enjoy the housing. So in this case, we're asking for the same right to live in this neighborhood, the San Carlos neighborhood, which is this community of our choice, and to have no limitation on the number of residents, or because we're being reasonable, we're asking for 10 residents. If you can go to the next slide. This again on page 10 reemphasizes that you can't impose special restrictions on persons with disabilities when you don't place those same restrictions on families within the municipality. You can go to the next slide. Yes. So just to summarize, we're requesting that condition number 1 read, the total number of residents is limited to 10. And we do think that that is consistent with the Uniform Development Code of Tucson. We'd like condition number 4 to be deleted. If the city is willing to change number 4 so that we must comply with all building and fire codes, we're okay with that also, with that language, if we want to do something different with condition number 4. Let me just look at my notes really quick if there's anything else here. I think that's it. If anyone has any questions, I'd be happy to answer them.
Are there any questions for the appellant?
I have a couple of questions right off the bat. When a resident leaves the Oxford House, how does a new resident get vetted? Do the members of the family make the decision as to a new resident, or is that made by the landlord, which is the Oxford House people? And I'd also like to know if there have been any recent complaints about the occupants that have been reported either to the city or to the police since these residents have been in place.
I can answer the first one. So the landlord actually is the property owner. The tenant is the organization. Let me just make sure I have it right here. It's called Oxford House Saguaro is the entity. And the members of the home vote on new members. They can also vote to kick members out. If they recognize that someone is no longer sober, if they're not following house rules, the house has actual house rules that the residents vote to approve, and they enforce those. And so it requires a vote to kick someone out of the house. It requires a vote to accept someone into the house. So they are very good at holding each other accountable. And I can ask Zach Martinez of Oxford House, he's a representative, to address whether there's been any complaints about the residents.
Please do. And state your name and address too, please.
My name is Zach Martinez. I'm the Senior Outreach Coordinator for Oxford House Incorporated. My address is 1920 West Lindner Ave, Mesa, Arizona, 85202. I can also give a little more clarification to question number 1, if you like. So if a bed becomes open inside of Oxford House Saguaro, the members will go through an interview process. They have about 30 interview questions that they will ask the person who's applying. Takes about 30 to 45 minutes. It's generally, what are your plans for recovery? Are you on any medications? Do you have a job? Are you willing to get a job? Do you mind doing chores? Are you willing to be a good neighbor? Just general questions like that. And then in order to be admitted into the house, they have to receive 80% of the vote. Now, as Ms. Dukes was saying, the members can also ask someone to leave the property, and that only takes a majority vote. So in order to get into the house, it's an 80% approval. And then if you're breaking the rules or you've returned to using or drinking, it's a majority vote to ask you to leave. And to answer the second question, as far as the complaints, and I'm sure Peter, when he comes up here, can attest to it. Since we started the lease, there have been no complaints going forward. And we've worked really hard over the last 6 months with meeting with the immediate neighbors and answering all their questions and any concerns or anything that they may have. We're pretty open book when it comes to Oxford House. So, we'll sit down and talk with anyone, answer any questions that may need. And if you have any other questions for Oxford House, I can answer that, like how it operates or anything like
I
that.
do have one question. If there are house repairs and things that need to be taken care of, is that the responsibility of the members or the responsibility of the landlord?
So we do have a normal tenant landlord relationship. If anything major, plumbing, electrical, or anything like structural happens, we will contact the landlord to fix that. If it's something along the lines of we were moving a couch or a table and we put a hole in the wall, typically we would just take care of that ourselves. And I can answer any more questions if there are any.
Yeah, I have a question. How long do individuals generally stay in this situation?
So we don't have a limit. There's no term limit. It's not that you come and live in Oxford House Saguaro and 30, 60, 90 days later you leave. They're allowed to live in the property as long as they follow the rules. And the majority of the rules, the big ones we have, are no drinking or using, paying their fair share, and then I can't think of the word, being part of the democratic process that runs the house. So every decision inside of the house is sat down at a table like this one, and kind of how y'all's meetings run. There's a motion made, someone seconds it, there's a discussion, and then a vote's taken place and it either passes or fails. Anything from whoever gets accepted to what kind of coffee creamer they want to buy for the house.
Yeah, one more question. Where are these people coming from?
So a majority of our members come from local treatment centers. We go and do presentations inside of there. We also take out of jail local recovery meetings, AA, NA, CA. There's a lot of A's nowadays. One of our members will go to a meeting and say, hey, our Oxford House or Saguaro has 2 openings, 2 open beds. Is there anyone here that's looking for a safe place to be in recovery? And then they'll say, yeah, and then they'll schedule an interview and go through the process. We also, at this time, also do take reentry prospects from ADOC.
Thank you for reminding me. Just curious how the operation is managed from the standpoint of whether the Oxford House is one of a number of houses, either elsewhere in Tucson or in other locations within Arizona or in other states, whether there's any unified management that directs the operations of each Oxford House. And as far as the landlord, is that the person that formerly lived in the house, or is that somebody that purchased the house and the property for the purpose of operating this operation?
So to answer your first question about having some sort of, I'm guessing you're looking for like the accountability for the house if it's not operating like an Oxford House. Is that what you're looking for with question 1?
The first part?
Yes, sir.
I just wanted to know initially whether this is a standalone operation or whether it is one of a number of facilities, either elsewhere in Tucson or elsewhere in Arizona or even outside the state, of a similar nature that are all owned by the same management company.
No, sir. So there are over 4,500 Oxford houses across the country as of this day. They're not all owned by one person. There's multiple landlords across the country that have either had prior rentals and then rented it to Oxford House, or have purchased properties specifically to rent it as an Oxford House. And then, I'm sorry, if you'll repeat the second part of that, I'm sorry.
I think the second part was about the landlord. is the landlord the owner of the property?
Yes, sir. The landlord owns the property, but he does not live there and he has no say in the operations of the house. It's strictly landlord-tenant relationship. We pay our rent to them at the first of the month and we bring up any concerns with repairs or, any things of those nature that need to be dealt with on a landlord-tenant level. Inside of the house and any of the operations of the house, the landlord has no say in.
Okay, thank you.
Yes, sir. Am I good?
I do want to bring up one new fact, in that Oxford houses are recognized by the federal government and also by jurisdictions across the U.S. as family uses. In fact, the SB 1308, which was recently adopted by our legislature and signed by our governor, it changed the definition of sober living home. And one of the exceptions to that definition, it actually describes the Oxford House use. It cites the actual United States Code provision that recognizes the Oxford House model. And so even in our new legislation that will take effect in about 90 days, the state has no regulation power over these types of uses because they are purely a family use.
I have a what? I have a question. Yeah, just Western curiosity, when the judge, when you first went before the judge in this thing, he determined that you were a family use. But then he limited you to 3 occupants. Well, if I read that properly, is that true?
We were limited to 4, and that was because as we were, the attorney for Oxford House, the main attorney out of Washington, D.C., Steve Poland, he had submitted 3 letters to the zoning administrator trying to get a determination that we weren't a group home and we were a family. And so during that time period, we told the court that we would limit ourselves to 4 individuals. And that's because the group home definition, if you recall, says 5 or more unrelated individuals. So we wanted to make sure we weren't in that group home category. We didn't want to be in violation of any zoning ordinance provision. So till this day, correct, Zach, we still have 4 residents? Yes, we still have only 4 residents. We're waiting for the city to, to make this determination so we can move forward with getting more tenants in the home.
Thank you.
You're welcome.
Is there anyone else wishing to speak in favor of this, or are you finished?
I am finished, but I think Peter Williams from the San Carlos Neighborhood Association would like to address you. And I'm going to fill out my name and address here.
Please state your name and address, please.
Yep. My name is Dr. Peter Williams, PhD. I chair the board of the San Carlos Neighborhood Association, and I live at 4435 East San Carlos Place North. It's the longest street address I've ever had, in Tucson, 85712. And I'll need to sign in. I wanted to show up today to it's a complicated case. I want to just cut to the chase and say the neighborhood association started out in, I was the one who wrote the first report of the code violation zoning that would have been in actually about the summer of 2023. We worked with Ward 6, Steve Kazatrick at the time, to get some attention to a problem that had been facing us for 20 years. The owner, who is the landlord, had been operating an illegal boarding house and an unlicensed care home for that time, changing hats, moving things around, but at times there were 40 people. We had assaults, we had, all messes of things. One of the neighbors got a variance to put a 7-foot fence up because of the bottles and drug paraphernalia and cigarettes that would be thrown over into where her grandkids played. We had had enough. I can't explain why the dates of when the lease and the code violation and all that, that has to do with delays on the process side for code enforcement. But I can show you, if it's relevant, when I filed and when we engaged to have enough is enough. We actually spoke, I testified on behalf of the city, working with the city attorney's office, Shilpa Hunter Patel, if I'm pronouncing her name correctly, was the attorney. We testified on behalf of the city against the owner, and at that time, it would have been Oxford House. But that's because they were the latest tenant. But let me be clear, we have had absolutely no issues with Oxford House since they've taken over. We have, while we were in court, I had to play the role that I had to play. I had to write the letters I had to write. You may have those, I don't know, we can provide those if you want. But we were most concerned about the owner's behavior and the violations that had happened there. None of those violations have anything to do with Oxford House. So that's part of what I see as the confusing part of this case. We have Oxford House as the appellant here. We have the owner as with a 20-year history of really being a horrible neighbor and a horrible member of the neighborhood. We think that we are in a situation where the Oxford House has established what could be called and was just called a normal relationship between a tenant and a landlord. And we have, as a neighborhood, we think, a normal relationship between a tenant who is a member and an active participant and a supporter of the neighborhood and the neighborhood itself. So you have a letter that I wrote and I signed, but that's on behalf of 3 of the 4 immediate neighbors adjacent neighbors of the Oxford House, the 2601 Swan Road property, and 77 other members of the neighborhood association. I gave them 2 weeks to review the letter. There was absolutely no concern raised. The neighborhood backs what you see in front of you as my letter. We support, from our perspective, the difference between 8 and 10 people in a 12-bedroom house is marginal. It really doesn't, it has nothing, it doesn't change anything. It's an acre-sized property. Most of the parking is in the back. We're not going to see issues of problems with parking on the street because it's Swan. You can't park on the street. It's all going to be parking in the back. We also, as you heard, we have met with Zach and other members of the Oxford House, call it the sort of management. We've also met with the residents, the current residents, and we've met with council to just talk these things through and figure out how they operate, what we're concerned about, that kind of thing. I would say that our conversations have been fantastic. And that's the basis for our willingness to write the letter that I wrote with clear support. So with that, I think all of the legal details, I will defer to what you've just heard. I won't repeat any of that. I think you get a sense of where we're coming from as a neighborhood, and that it's taken a while to get to where we are now, but I'm confident and comfortable in expressing the support for this appeal.
Thank you. Are there any questions? Thank you, sir.
Thank you.
Anyone else wishing to speak in support of this? Hearing none. I will now open the floor to anyone wishing to speak in opposition to this case. Seeing none, I will now close the public hearing on this. I'll open it up to the board? Any questions or comments?
Um, Thank you, Mr. Chair. For me, the issue here is more that there's a permit on record that has a condition that states that the house must house less than 8 persons not related by blood. That is not a discriminatory policy. It is not based on any of the statutes that were quoted in the staff report. It's simply a permit of record that, to anyone's knowledge, has not expired or ever been rescinded. But having said that, I think it's pretty remarkable that there's a neighborhood out there that has worked with a facility such as this that are housing unrelated individuals who are considered disabled under ADA conditions, and that they feel comfortable with the proposition that there could be as many as 10 residences in that property. And for that reason, I would support a motion to modify the zoning examiner's decision, and that we would somehow clarify that we have altered the condition in that 1991 permit to allow this to occur, and that the building must house less than 11 people, I suppose would be the wording, or that condition is removed from whatever that permit was. But I think that in the interest of the legal conditions that we're considering here, that there needs to be some acknowledgement that we are rescinding the condition in that 1991 permit. Thank you.
Mr. Chair, may I add to that?
What?
I would just want to make it clear that by modifying the zoning administrator's determination regarding the number of residents, that cannot modify the condition of the building code, of the prior permit, I'm sorry.
So how does that legal snafu get resolved? Does this supersede that condition then?
No, they would need to apply for a new permit.
If this moves forward, I would really be in favor of keeping that condition, is that if it goes up, then they have to comply with the more strict building regulations associated with this. I personally have a somewhat of an issue of referring to this thing as a family, but that's really not my purview. I mean, I've dealt a lot in my career with similar facilities, and we've always used the behavioral health classification for any of these particular properties. It was the same, alcohol rehabilitation sorts of uses, but considering this a family is just a real stretch for me, but
Mr. Chair, may I ask for an additional item?
yes.
In the motion, if you are going to modify the determination, I think it needs to be clear as to how the determination was faulty or why that number is not appropriate based upon the information that was provided in the determination itself.
Should I take a stab?
Go for it. Wait, could you answer her question, please, first?
I am going to try to do that in the motion.
All right.
Okay. I move that we modify the zoning administrator's determination related to case 10-2503 as follows. Revise condition number 1 to state total number of residents is limited to 10, and to delete condition number 4, not 3, is it? It's 4. To delete condition number 4 and to revise condition, wait. To delete condition number 3, I'm sorry, further permits not assumed. So that condition is not necessary if we modify the number of residents?
Mr. Chair and Ms. Paulus, so the motion template provided before you was a recommendation from our legal counsel. She found it appropriate to delete condition number 3 and to revise condition number 4 in order to state that that it be subject to all applicable building
Okay.
codes.
Let me start over. I move that we modify the zoning administrator's determination related to case 1025-03 as follows. Revise condition number 1 to state total number of residents is limited to 10. Delete condition number 3 and revise condition number 4 to state the use will be subject to all applicable building codes. The reason that I believe that we can make this modification is that really none of the statutes that were cited actually relate to this particular use. The definition of a family in the UDC is met by the conditions of the Oxford House, and I believe that the fact that the people who live adjacent to this property in the neighborhood also believe that this is a reasonable accommodation, and that this determination, I believe, brought in a lot of issues, none of which directly apply to what Oxford House is doing as a care facility. So it might be interesting for the Planning and Development Services Department to examine this kind of use in the future so that we might be able to have very clear directions on the number of unrelated individuals who are considered a family living under these conditions. Thank you.
Before acting upon that motion, I just want to add a couple of comments. And one is that my reading of the zoning administrator's determination is that it was very sound and very reasonable and based upon well thought out analysis of the issue. And I find the bottom line with regards to the number of units that limited to 8 to be very reasonable. But I also find that the presentation presented to us by the appellant to be very thorough and very reasonable. And I want to add, a lot of the arguments are, for the most part, relative to more appropriate to a rezoning than an appeal of a zoning administrator's determination. And I don't believe I've heard that there was an error in that zoning administrator determination. Nonetheless, I don't find that 10 is unreasonable, and I am impressed by the support there is by the members, but also the neighborhood for the use. So I'm inclined to support the request, even though I believe the basic arguments presented in the zoning administrator's determination still to be quite valid. So if there's a motion on the floor, I will second it.
Mr. Chair, I do have a question of staff. I know I made the motion, but if this variance goes through, is it applied to the applicant or is it applied to the property? So should the applicant no longer be the tenant, does that variance still apply or does the variance then go away?
I'd like to step in just quickly to make sure that we are very clear in what we're talking about. All we're addressing here is whether the zoning administrator's determination of the appropriate land use class under the UDC was made in error. So this isn't a variance. Your scope of review is not the same as if it was a variance. We're focused on whether this particular use by Oxford House, what then the determination that Oxford House's use is most appropriately fits into the family land use class with a limitation of 8 residents was made in error by the zoning administrator. So we need to be very clear when we are making the motion that that's what we're addressing and that's what we're deciding. And it is specific to the Oxford House's use.
It's the Oxford House's use of this particular property, correct?
Correct.
Question though, that if there was another Oxford House proposed for another parcel of land within the boundaries of the city of Tucson, would they automatically be allowed 10 residents, or would they be restricted per that determination of 8?
Mr. Chair and Member Marks, a zoning administrator determination can be set for precedent on other locations or for the entire city. In this case, the determination has not been set as precedent for all similar cases. It applies only to this property.
Ah, okay. Okay, yeah, my only comment is this is an R1 zone. Our R1 is our most restrictive zoning classification for residential. And I have, I mean, live in an R1 zone myself, and if this were an R2 or an R3, I'd be feeling differently about this, but I'm really not. But so again, with the other problems I've stated before, I'm not sure I can support this. Yeah, that's true. I also got a call a second. Do I have a second? Oh, okay, sorry, missed that one. Okay. All those in favor of the motion say aye. Aye.
Aye.
Aye.
All those opposed? No. That's, motion carries, I guess.
That's a vote of,
Oh, that's a vote of 4-1. There's 5 of us here? Yeah, okay, 4-1.
Yes,
Motion
that's correct.
carries. What?
Yes, that's correct.
So the motion does in fact carry, so thank you very much.
so now that the case is over, can I ask another question of staff
Certainly.
about this case? Or is the case officially closed for public record?
We
Case
should
is
close the
officially
public
closed.
hearing first, and then you can ask the question.
Okay.
Yeah, the case is closed.
So what would have been, what would have been a better way to approach this issue? Should the issue have been a request for a variance to the limit of 8 as defined by a family? Is that something they could have requested a variance for?
As the UDC does not have a limit on the number of residents, it was only a condition placed in this particular determination. You can't request a variance for something that's a condition of a ZAD. This is the correct mechanism to ask for that in this particular case.
Okay, any other questions for staff on this? Okay, we are done then. Thank you very much. Good. Okay, thank you, everybody. We are adjourned.